मेरी सगाई में ही मेरे ससुराल वालों ने 30 लाख रुपए श्रीधन, 30 लाख रुपए के बजट में शादी व सगाई में रुपए 40 लाख नकद कैश की मांगनी की थी। नकद कैश नहीं दिए जाने के कारण शादी के पहले ही हफ्ते से मेरे पति और ससुर के द्वारा परेशान किए जाने लगा। मेरे पति ने पासपोर्ट वीजा की जानकारी व शादी के पंजीकरण सर्टिफिकेट इत्यादि अमेरिकी अधिकारियों देकर गलतफहमी दूर करने के स्थान पर मुझे अपने स्पाउस वीजा पर अमेरिका में साथ रखने के लिए दिए जाने वाले बैंक बैलेंस में कमी बताकर मुझे साथ रखने के लिए अपने स्पाउस वीजा F2 के नाम पर मेरी बुआ जो अमेरिका में रहती हैं उनसे 24 लाख रुपए वसूल लिए। उसने मुझे उकसाया कि मैं उसकी पहचान व नाम छुपाकर अपने स्वयं की पढ़ाई के लिए स्टूडेंट वीजा प्राप्त करूं, जिसमें मेरा पति का नाम कभी भी नहीं आना चाहिए। मेरे द्वारा ऐसा करने से इनकार किए जाने के कारण वह मुझे तलाक की धमकी दिए जाने लगा। Sir, if related to punishment as sir for the FIR registered in Indore, in this case a charge sheet has also been filed. During the pendency of this application, the charges have been framed against me. The revision has been dismissed, and also my father's petition for quashing has been dismissed. But I would like to argue, sir, on the following grounds. Sir, first of all, this is an abuse of process by the complainant and her family. Sir, second ground is that the evidence collected. I will go through the evidence, sir, one by one. Sir, the evidence collected during the investigation does not disclose commission of any offence, sir. That is, there is absolutely no corroborative material collected during the investigation that supports the allegations. Sir, then I would also like to argue that this is an ulterior motive to seek vengeance and to destroy my life, sir. After I refused to succumb to the complainant's repetitive demands of attempting to mislead me, threaten me, misguided me to send their daughter illegally to United States of America, where she was already deported and banned from United States of America for her proven misconduct and abuse of her visa. Sir, there is also an inordinate delay in lodging all the criminal complaints, sir. This family has filed all the complaints after I had filed for divorce. So, sir, she was not living with me since 5 years with marriage. And as soon as I filed for divorce, she went on to the court. She approached the courts, every court with unclean hands.
You are seeking quashment of FIR?
Yes, sir.
Read the FIR.
यस सर। विश्वविद्यालय पंथा उत्तराखंड के लेखी आवेदन पत्र प्राप्त हुआ, जिसके माध्यम से धारा 420, 406, 498 ए भावी एवं दहेज प्रतिषेध अधिनियम को पंजीबद्ध किया जाता है। आवेदन पत्र निम्नानुसार है कि श्रीमान थाना प्रभारी महोदय थाना विजयनगर, मुझे प्रार्थनी के पति एवं ससुर द्वारा गाली गलौज व प्रताड़ित कर 50 लाख रुपए की बार बार दहेज की मांगनी व श्रीधन की हेराफेरी किए जाने के बाबत शिकायत। सेवा में निवेदन है कि मैं प्रार्थनी मोनलगढ़ निवासी हाल मुकाम 97 बीजी स्कीम 74 सी विजयनगर इंदौर की शादी निखिल पिता सुनील कुमार रस्तोगी निवासी I-236 फूलबाग जीबी पंत विश्वविद्यालय परिसर नगर उत्तराखंड सर 25/11/2017 को हुई थी, जिसमें मेरे माता पिता व रिश्तेदारों के द्वारा मेरे ससुर वालों की मांगनी के आधार पर शादी में लगभग 30 से 62 लाख रुपए खर्च किया गया था। महोदय, मेरी सगाई में ही मेरे ससुराल वालों ने 30 लाख रुपए श्रीधन, 30 लाख रुपए के बजट में शादी व सगाई में रुपए 40 लाख नकद कैश की मांगनी की थी, जिसमें मेरे पिता द्वारा नकद कैश की मांगनी नहीं मानने के कारण ससुराल वालों ने दिल्ली से शादी व सगाई का प्रोग्राम करने व महंगे उपहारों की डिमांड रखी थी, जिसे बड़ी मुश्किल से पूरा किया गया था। लेकिन नकद कैश नहीं दिए जाने के कारण शादी के पहले ही हफ्ते से मेरे पति और ससुर के द्वारा परेशान किए जाने लगा। महोदय, मेरे पति ने खुद को अमेरिका में नॉर्थ कैरोलिना यूनिवर्सिटी से PhD कर वापस भारत आकर नौकरी करते बतलाया था। शादी के बाद मेरे पति को PhD के दौरान मुझे स्पाउस वीजा की प्रक्रिया में लगने वाले समय के दौरान मुझे B2 ट्रैवल वीजा पर आने को कहा, जिसके आधार पर मेरे पिता ने शादी की थी। लेकिन शादी होने तथा संपूर्ण गहने नकदी व जेवर आदि प्राप्त कर लेने के बाद भी मेरे पति ने जानबूझकर शादी का पंजीकरण ना कराया और मुझे B2 ट्रैवल वीजा पर मेरे चाचा जो अमेरिका के शिकागो शहर में रहते हैं उनके पास आने को कहा, तथा यह कि वह मुझे शिकागो के अपने पास ले जाएंगे, यह कहकर मेरे पति अपना पता, पासपोर्ट व वीजा की कोई जानकारी दिए बगैर ही वापस अमेरिका चले गए। B2 ट्रैवल वीजा पर शिकागो शहर में प्रवेश देने के पूर्व जांच में अमेरिकी अधिकारियों को जब यह पता चला कि मेरे पति भी अमेरिका में हैं, पति के पासपोर्ट व वीजा की जानकारी, शादी के पंजीकरण सर्टिफिकेट दस्तावेजों के अभाव में मेरे पति को अमेरिका का स्थायी नागरिक मानकर तथा मेरे पास वांछित दस्तावेजों के ना होने के कारण मुझे प्रवेश देने से इनकार कर उस वीजा पर भी अमेरिका में प्रवेश करने की सलाह देते हुए वापस भारत लौटा दिया। मेरे पति ने पासपोर्ट वीजा की जानकारी व शादी के पंजीकरण सर्टिफिकेट इत्यादि अमेरिकी अधिकारियों लेकर गलतफहमी दूर करने के स्थान पर मुझे अपने स्पाउस वीजा पर अमेरिका में साथ रखने के लिए दिए जाने वाले बैंक बैलेंस में कमी बताकर मुझे साथ रखने के लिए अपने स्पाउस वीजा F2 के नाम पर मेरी बुआ जो अमेरिका में रहती हैं उनसे 24 लाख रुपए वसूल लिए। इसके बाद भी मुझे स्पाउस वीजा के आवश्यक दस्तावेज नहीं देकर मुझे जानबूझकर अपने साथ रखने से रोका गया। न केवल इतना, वरन मुझे जानबूझकर अपने साथ नहीं रखने पर मेरे लिए पिता की संपत्ति का हिस्सा बताकर वे मेरे परिवार के अन्य विवरण के आधार पर स्पाउस वीजा F2 ना देकर स्टूडेंट वीजा F1 के लिए बाध्य करने लगातार तरह तरह से प्रताड़ित व अपमानित किया गया एवं स्टूडेंट वीजा के नाम पर 50 लाख रुपयों की मांगनी की जा रही है, जिसके नहीं दिए जाने के कारण निखिल ने अपने वकील को एक झूठा पत्र बनाकर ईमेल भेजा जिसमें यह लिखा था कि हमें मोनल का वीजा के लिए तैयार करने में समय लगेगा, जबकि मैं वीजा लेने में पूरी तरह सक्षम थी। सर, ये सारे इंपॉर्टेंट पॉइंट्स हैं सर, इस पे मैं एक बाय वन बाय वन आई विल कम टू दिस। सर, दीज आर क्लेवरली ड्राफ्टेड एलिगेशंस। जबकि मैं वीजा लेने में पूरी तरह सक्षम थी और पहले भी स्वयं यूएस का वीजा प्राप्त किया था, जिस पर मैं 2 बार यूएसए की यात्रा कर चुकी थी, और यह पत्र झूठा था जिसका आशय मेरे वीजा को बाधित करना था और बाधित कर दिया। जब मेरे माता पिता ने मेरे पति व ससुर को समझाया तो मेरे सास ससुर 9/4/2019 को इंदौर में मेरे पापा के घर आकर रुके और उन्होंने मेरे पति के साथ टेलीफोन पर कॉन्फ्रेंस से बात कर मुझे स्पाउस वीजा के स्थान पर स्टूडेंट वीजा दिलाए जाने के नाम पर 50 लाख रुपए की मांगनी की गई। और जब मेरे पिता ने रुपए देने से मना कर दिया तो मेरे ससुराल वालों ने वीजा बनवाने के लिए की जाने के लिए समर्थ कार्यवाही बंद कर दी और कहा 50 लाख रुपए तो देना ही पड़ेंगे। जब मेरे पिता ने स्पाउस वीजा के लिए मेरे इसे आवश्यक दस्तावेज देने वास्ते पत्राचार किया, उसने मुझे उकसाया कि मैं उसकी पहचान में नाम छुपाकर अपने स्वयं की पढ़ाई के लिए स्टूडेंट वीजा प्राप्त करूं, जिसमें मेरा पति का नाम कभी भी नहीं आना चाहिए। मेरे द्वारा ऐसा करने से इनकार किए जाने के कारण वह मुझे तलाक की धमकी दिए जाने लगा और इसके बाद ही मेरे पति व ससुर ने मेरे श्रीधन को बेचना शुरू कर दिया, जिसका पता मुझे तब चला जब इंटरनेट पे मेरे माता पिता द्वारा मांगी गई महंगी घड़ियां जैसे राडो, फिटबिट, लेडीज वॉच इत्यादि बेचने का विज्ञापन देखा। उनको मेरे पति द्वारा बेच दिया गया तथा उस पैसों से अपने निजी उपयोग में लिया गया था। महोदय, मेरे ससुर व पति एक साथ मिलकर मुझे ससुराल तथा पति से जानबूझकर दूर रखा। मुझे सबके सामने बार बार प्रताड़ित कर नीचा दिखाकर जलील किया गया और मेरे पति और मेरे ससुर की लगातार बढ़ती हुई मांग तथा स्टूडेंट वीजा के नाम पर 50 लाख रुपए की मांग से परेशान होकर को पूरा न करने पर मेरे साथ होने वाली प्रताड़ना से परेशान होने के कारण अपने पिता के घर में निवास कर रही हूँ। मेरे पति व ससुर दहेज के लोभी हैं। वे आए दिन दहेज की मांग करते रहते हैं। मेरी शादी के बाद से ही मेरे श्रीधन, वस्त्राभूषण व विवाह में प्राप्त उपहार व घर गृहस्थी का सामान ससुर ने रख लिया है, जो आज तक भी उन्हीं के पास है और मांगने पर भी मेरे श्रीधन देने से मना कर दिया है। उसमें से उसको भेज दिया गया है। मुझे अपने परिवार वालों से रुपए लाने के लिए प्रताड़ित करते रहते हैं। कभी स्पाउस वीजा, कभी स्टूडेंट वीजा के लिए पैसों की मांग करते हैं। मांग पूरी ना करने पर प्रताड़ित कर नीचा दिखाते हैं और जलील करते हैं। मेरे पति के बैंक अकाउंट में पैसे नहीं थे, वह शादी का रजिस्ट्रेशन भी नहीं करवाया और मुझे ये झूठ कर कहा कि वह 2 सप्ताह में मुझे स्पाउस वीजा दिलवा देगा, जो कि झूठा था। अतः प्रार्थनी यह निवेदन करती हूँ कि मेरे ससुराल पक्ष में मेरे पति निखिल रस्तोगी, सुनील कुमार रस्तोगी के खिलाफ मुझे पूर्व में ससुराल में गाली गलौज करने, प्रताड़ित करने, दहेज मांगने और बार बार रुपयों की मांगनी करने व उनके पास रखे श्रीधन व वस्त्रभूषण वैवाहिक उपहारों को बेचने की पूर्व नियोजित साजिश किए जाने पर आवश्यक कार्यवाही दर्ज करने की कृपा करें। Avedika Monal Garg.
So the petition for 482 was filed by your father.
Yes, sir.
That has been dismissed.
Yes, sir.
Where is that order?
My lord.
You argue.
Yes, sir. सर सबसे पहले सर आई वुड लाइक टू से कि इन्होंने काफी सारे मटेरियल्स दे हैव सप्रेस्ड एंड कंसील लॉट ऑफ फैक्ट्स मटेरियल्स in very obvious cases sir the court can look into some of the facts and some of the external documents produced by the defense. Second thing sir, there are a lot of allegations that are not corroborative with their own material that they have submitted during the investigation. So I would like to highlight those to show that this is a family of abusers. Third thing, sir, I've also annexed a lot of Madhya Pradesh court findings, Supreme Court finding newspaper articles regarding the misconduct of this family, that how they have been sequentially prosecuting the entire society around them since the last 15 years, using the same set of lawyers, same set of false allegations, and same set of witnesses. So with that, sir, I would like to proceed with my petition. So first of all, sir, there is an allegation of $30,000 that were transferred to me by her aunt. Sir, the police has not recorded any statement from the aunt. It is true that her aunt had paid me $20,000, $30,000. Those are not dowry. Those are not. Those were to just show funds in the bank account because that's a U.S. immigration visa requirement. Second thing, sir, that money was returned to her in the year 2019, and the same is also duly reported in the of charge sheet. When I had applied for anticipatory bail, when my father had also applied for anticipatory bail. However, the police has not made that part of the record. They have still proceeded with the charges of 420 and 406, alleging that the money has never been returned. So they have proceeded on to frame the charges against me. So, sir, to that, I would like to show page number.
Charges are also framed.
The charges are also framed because sir, the court did not consider any material fact outside for defense documents.
For discharge also, that is mentioned in the order passed in the case of his father.
So application for discharge is also dismissed.
Yes.
It was dismissed. Review also dismissed.
So there are certain cases, sir, where the court can look into the cases even after these. And sir, during discharge and during framing of charge, the courts are not bound to consider any external documents. But if I may, sir, there are some studies from Supreme Court that I would like to show. So this is in the High Court of Jabalpur, Madhya Pradesh. This is on 14th of November 2024. This is
judgment you are placing.
Yes, sir. This is the latest judgment, sir. I can have.
Have you got the copy of that?
Yes, sir. I have. So this is MCRC number 44242 of 2023, Ganpat Meena and others versus State of Madhya Pradesh and another. Sir, it also discusses that when is the case of inordinate delay, especially when the wife is filing after the husband has filed for divorce, it takes considered into that account, and it also shows under what circumstances the court can consider external materials. Sir, I would like to direct your attention towards.
At this stage, whether we can look into the evidence.
Yes.
There are those, because you are seeking quashment of the FIR and the subsequent proceedings.
Yes, sir.
So what is the law for at this stage?
Sir, that is what I'm like in certain cases when it becomes obvious, the court can consider the documents. They are very rare cases, but the court can proceed with those. And there are multiple Supreme Court findings. That's what I'm presenting in this case.
Yes.
So further, in case of Rohit versus State of MP reported in 2019, considering the similar facts has been involved in the present case, the High Court has observed as under 10 para 9, like it's under the courts. The first contention, which appears to be preliminary in nature, is that the documents which are brought on record, recording the complaint made by the applicant number 1 to the Superintendent of Police Ratlam and filing of application under Section 9 of Hindu Marriage Act for execution.
देखिए पेज 12 पे ही.
Yes, sir.
जो इस केस में रेफर्ड.
Yes, sir.
विजय नरवेकर करके इसको कोर्ट ने साइड किया है. 2008 volume 14 SCC1 है ना?
Yes, sir.
Then para 21, 22 of that judgment.
Yes.
Read para 22.
So we should also keep in mind that it is well settled that a judgment of the court has not to be treated as a Euclid's formula. Why Rajbir Singh Dalal versus Chaudhry Devi Lal? Sir, I know it's not to be treated as a Euclid's formula. Thus, in our opinion, while it is true that ordinary defense material cannot be looked into by the court while framing of the charge, in rare and exceptional circumstances where some defense material, when shown to the trial court, would convincingly demonstrate that the prosecution version is totally absurd or preposterous, and in such very rare cases, the defense material can be looked into by the court at the time of framing of the charges or taking cognizance. In our opinion, therefore, it cannot be said as an absolute proposition that under no circumstances can the court look into the material produced by the defense at the time of framing of charges, though this should be done in very rare cases. So now this is regarding the framing of charges where they are clear that no defense material can be looked into, but they will also contradict regarding the powers of 482, sir, in the next paragraph. So allow me to read it.
Yes.
Where the defense, okay, sir, 38, in the middle of this same paragraph. In my view, therefore, there is no scope for the accused to produce any evidence in support of submissions made on his behalf at the stage of framing of charge, and only such materials they can. However, in a proceeding taken therefrom, under section 482 CRPC, the court is free to consider the material that may be produced on the behalf of the accused to arrive at a decision whether the charge is framed could be maintained. This, in my view, appears to be the intention of the legislature in wording sections 227 and 228. The way in which they have been worded, as explained in Devilnath Paridhi case, so they have again cited any judgment. And ultimately, sir, on page number 12, this High Court gave the finding regarding these studies on paragraph number 12. Page number 12, sir. The consideration of the reproduced portion clearly indicates that it is open to the court to inquire into the circumstances and the context in which the complaint has been lodged. Sorry, not this one. Sir, 7th paragraph.
Yes.
Has to be applied to no useful person like to start. I think it's in the previous paragraph only where, sir, it is written that in extreme cases, sir, where it becomes obvious.
That is the law.
Yes, sir. So
In very extreme and rare cases.
extreme and rare cases, sir.
There, that if the defense is considered at the time of framing of the charge, because the court was dealing with the framing of the scope of section
Sir,
CRPC for the purpose of framing of the charge.
yes, ma'am.
So they had that the ordinarily the defense would not be considered. Only
Yes, sir.
Except in rare circumstances.
Yes, sir. I'm not challenging that. I'm just saying that some of the defense documents were not considered during the framing of charge.
Defense document. Let us see that we are in 482.
Yes, sir. In 482.
Rightly, those
Yes, sir. I want to.
documents you want that the court should look into.
Yes, sir. That is what I want to show. Sir, first of all, they have said they have alleged that I have cheated them of $30,000. So, sir, I would like to place your direction towards Annexure K, page number 20.
Page number 20.
Oh, sorry, not sir. Page number 340. 340. So again, the dates would be very important in this case. So that is the Annexure K, page 340. NC state seeking status of the mail check. Sir, the date of this email is October 31st, 2019.
Yes.
Dear Rekha Bua, I'm doing good. I hope the same for you. I mailed a check of $30,000 via FedEx. And then she responded that she has got the check. And then, sir, on page number 341, here's my bank account statement that the check was cashed by her aunt. And on page 344 also, sir, it shows that the check 1032 amounting to $30,000 has been cashed by Rekha Bansal. The photos of the check are, sir, on page number 345. The check was addressed to Rekha Bansal, the same lady who had given me $30,000. Now, sir, the date is 2019. The money was already paid to them. However, the complainant, after receiving the notice of divorce from me, in order to mislead the court reports and in order to falsely accuse me, she said that the money was never returned to her and I duped her of 30,000 US dollars. The FIR was filed in 2022.
Yes.
So, sir, that is 3 years after the money was already returned to her. So, this was also presented during, sir, when my father appeared for anticipatory bail here. The objector, Lakan Singh Chandel, appeared for them. Again, pressed these charges that he has eloped with 30,000 US dollars. So, sir, my lawyer had already placed that money has already been returned. Then again, when I applied for anticipatory bail, the objector again pressed these charges. And then after that, sir, when the charge sheet filing came, the police completely excluded that from the investigation and pressed on the materials that I have duped them, this family, of 30,000 US dollars, despite the money was already being paid 3 years before the FIR was registered. Sir, this court had made a finding regarding that during my anticipatory bail hearing. That's also part of the charge sheet. If Your Honor may, I can read that, sir, to show the misconduct of this family, how habitual liars they are and how they deceive the entire society.
When it's your bail,
A duty of the public prosecutor is to act fairly and not merely to obtain conviction by any means, fair or foul. If the accused is entitled to any legitimate benefit, the public prosecutor should make it available to him or inform the court, even if the defense counsel overlooked it. Learned counsel for the objector submits that he is only assisting public prosecutor in the present case and is not playing the role of public prosecutor. He seeks permission of this court. He was given the permission, sir. Then I said the last second last paragraph on the next page, sir, page number 4. We did our side of the arguments and then the objector came. So learned counsel for the respondent said an objector opposed the prayer for grant of anticipatory bail and submits that till this date the applicant has not surrendered before the investigating agency and there is all possibility of fleeing from India. It is further submitted that the applicant in a pre-planned way flashed the conspiracy to cheat the complainant and had taken 24 lakhs from her aunt in the name of preparation of various official documents. Combating the aforesaid, learned counsel for the applicant has drawn attention of this court to the email messages where the aunt has acknowledged the transfer amount of rupees 24 lakhs in her account. So, sir, even in the anticipatory bail, their objector tried to deceive the court by presenting. The police has never, in the part of investigation, made that a part and went on to proceed with framing the charges, with filing the charge sheet. The charge sheet, sir, there is no application of mind, sir, by the IO. It is whatever the complainant that was, whatever the statements that were drafted by the complainant, as is they are converted to an FIR, and the materials are not even looked at. Even many of the materials do not corroborate with their allegations of this family. Now, sir, why this is important is I would have another finding. Sir, this finding has also been used by various Madhya Pradesh Highcourts against the complainant's family as well. So, this is a case against the complainant's father, which was quashed. So, he has been abusing lots of people in the last 15 years. So, sir, this is very relevant. So, paragraph 14 in the courts. At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either the inherent powers under section 482 of the
reading page.
So page number 14th of this order, page 329.
329.
Yes, sir. So paragraph 14 under the courts. At this stage,
Yes.
we would like to observe something important. Whenever an accused comes before the court invoking either the inherent powers under the section 482 of the Code of Criminal Procedure or the extraordinary jurisdiction under Article 226 of the Constitution to get the FIR or the criminal proceedings quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with the ulterior motive of taking vengeance, then in such circumstances, the court owes a duty to look into the FIR with care and a little more closely. We say so because once a complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, etc., then he would ensure that the FIR complainant is very well drafted with all the necessary pleadings. The complainant would ensure that the avertments made in the FIR are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it will not be just enough for the court to look into the avertments made in the FIR complainant alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offence are disclosed or not. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the avertments, and if need be, due care and circumspection try to read in between the lines. The courts are allowed to read between the lines, not solely base a judgment only on the prima facie reading of allegations, especially in that case. The court, while exercising its jurisdiction under Section 482 of CRPC of article, need not restrict itself only to the stage of the case, but is empowered to take into account the overall circumstances leading to the registration of the case as well as the material collected in the course of investigation. Take, for instance, on hand, multiple FIRs have been registered over a period of time. It is in the background of such circumstances the registration of multiple FIRs assumes importance, thereby attracting the issue of wreaking vengeance out of private or personal grudge. Now, sir, it is known thing that women file false cases. It's a package of 498A. It's a package of Section 9. It's a package of domestic violence. This family went a step ahead and they also filed a criminal defamation case against me. I have filed multiple perjury applications in all the cases, none of which have been dismissed. But this family was unable to get those cancelled, so they have filed another case. So that is why this case becomes importance. And sir, this is also a case of a family that has been abusing the laws for more than a decade. Now, sir, I'll come to the contents of the FIR, some of the pleadings to show that how vague they are and how they do not corroborate with even the materials collected during the investigation.
Mr. Rasturi,
Yes, sir.
your father's petition
Yes, sir.
on the basis against the same FIR,
Yes, sir.
husband, has already been dismissed.
Yes, sir.
That order was challenged somewhere or it has.
It was not, sir.
So once this court has already considered the allegations in the FIR,
Sir, I'm a different accused.
you may be, but FIR allegations, because while deciding the application, the petition of your father, court considered the allegations against father and also against you, husband of the couple. So how do you overcome this judgment?
Sir, I would of course challenge this case, but the problem is my father does not want to go further. He has lost hope with all the judiciary system because my wife never lived with my father for a single day. She did not even live with me for a single day. The very intent she had in plans to settle down, but the court could not look into those facts of the case. So that's
Because the role of every court is a different.
yes, sir.
Provision.
Sir, it is, but that order was
Section 482.
so that order was obtained through fraud and willful misrepresentation. Like I've already said, sir, the public prosecutor as well as the prosecution are always repeatedly pleading with evidence that is known to be false. It was clear that the money was paid. It is extremely clear that the wife had filed after receiving a notice of divorce. She had not lodged any complaint in the 5 years. So how come as soon as I filed for divorce, she files a case against me and alleges these things, and where is the evidence to corroborate with her allegations? I'm only being prosecuted solely on the basis of cleverly drafted allegations. And sir, I'm already showing the conduct of this family, how they have been deceiving the courts since the last 15 years, not just me, against the entire society. This family has been prosecuting using very well drafted allegations. So this is not just against a crime against me, but also crime against the entire society. So we lived in separate countries, and then also I incurred domestic violence to her in different countries for 5 years, and yet no complaints. This person files hundreds of false cases, but for 5 years he could not file any case against me. But as soon as I file for divorce, cases are registered.
Yes.
So the court has the power to take suo motu cognizance of any order that has been obtained through fraud or willful misrepresentation.
So in substance, your submission is that it is nothing but an abuse of the process of law.
Yes, sir.
This is in substance, your contention.
Yes, sir.
That she filed a false report was lodged after receiving, though they were aware that the amount has already been returned
Yes, sir.
to their aunt.
Yes, sir.
And number two, that after receiving the notice of the divorce petition,
Yes, sir.
The criminal cases have been lost.
Yes, sir. And sir, the same Jabalpur Court, Honorable Jabalpur Court judgment can also be used. Sir, this clearly says that if the women file after 5 years or 6 years, especially when they have left the matrimonial home, then they have to be treated with utter suspicion, and there has to be corroborative material to go with the allegations. Simply allegations disclosing a crime should not work. I can also go on about lot of illegalities that had happened during the investigation.
So you will continue or you will conclude it, because today bench is only up to this. If you want to continue, we will take it tomorrow.
Okay, sir.
Yes, we will continue. Let him argue.
So today's argument, would that be on record or?
We will remember, don't worry, I have made notes.
I
Everything
have to
will be,
repeat all of it.
because time is not there. We keep it tomorrow.
So can I get early hearing, like because I come from Delhi, so
We will take it tomorrow.
Yes.
As early as possible.